welcome back to another episode of Kylie Reads the History Textbook, Section 3. This is part 2 of the reading for Honors U.S. History. Section 3, Suffrage and Civil Rights. How important is the right to vote? For those who do not have it, the right can seem as important as life itself. Indeed, in the Deep South of the 1960s, civil rights workers suffered arrests, beatings, shocks with electric cattle prods, even death, all in the same name of the right to vote. Their efforts inspired the nation and led to large-scale federal efforts to secure the right for African Americans and other minority groups in the United States. The 15th Amendment. The effort to extend the franchise to African Americans began with the 15th Amendment, which was ratified in 1870. It declares that the right to vote cannot be denied to any citizen of the United States because of race, color, or previous condition of servitude. The amendment was plainly intended to ensure that African American men, nearly all of them former slaves and nearly all of them living in the South, could vote. The 15th Amendment is not self-executing, however. In other words, simply stating a general principle without providing for a means of enforcement was not enough to carry out the intention of the amendment. To make it effective, Congress had to act. Yet for nearly 90 years, the federal government paid little attention to the voting rights of African Americans. History during that period. African Americans were generally and systematically kept from the polls in much of the South. White supremacists employed a number of racist tactics to that end. The major weapon was violence. Other tactics included more subtle threats and social pressures, for example, firing an African American man who tried to register or vote, or denying his family credit at local stores. More formal legal devices were used as well. The more effective were literacy tests. White officials regularly manipulated those tests to disenfranchise African Americans. Registration laws served the same end. As written, they applied to all potential voters. In practice, however, they were often administered to keep African Americans from qualifying to vote. Poll taxes, white primaries, gerrymandering, I don't know if I'm pronouncing that right, and several other devices were also used. Gerrymandering is the practice of drawing electoral district lines, the boundaries of the geographic area from which a candidate is elected to a public office, in order to limit the voting strength of a particular group or party. The white primary rose out of the decades-long Democratic domination of politics in the South. It was almost a given that the Democratic candidate for an office would be elected. Therefore, only the Democrats ordinarily nominated candidates, generally in primaries. In several southern states, political parties were defined by law as private associations that could exclude whomever they choose, and the Democrats regularly refused to admit African Americans. Because only party members could vote in the party's primary, the African Americans were then excluded from a critical step in the public election process. Court rulings. The Supreme Court outlawed the white primary in a case from Texas, Smith versus Allwright in 1944. The court held that nominations are an integral part of the election process. So when a political party holds a primary, it is performing a public function and is bound by the 15th Amendment. The Supreme Court outlawed gerrymandering used for purposes of racial discrimination in Gomillion versus Lightfoot in 1960. There, the Alabama legislature had redrawn the electoral district boundaries of Tuskegee, effectively excluding blacks from the city limits. The court ruled that the legislature's action violated the 15th Amendment because the irregularly shaped district clearly was created to deprive blacks of political power. Led by these decisions, the lower federal courts struck down many practices designed to deny the vote to African Americans in the 1940s and 1950s. So the courts could act only when those who claimed to be victims of discrimination sued. That case-by-case method was at best agonizingly slow. Early civil rights legislation. Finally, largely in response to the civil rights movement led by Dr. Martin Luther King Jr., Congress has moved to act. In the late 1950s, it began to enact civil rights laws specifically intended to implement the 15th Amendment, Acts of 1957 and 1960. The first of the laws Congress passed to enforce the 15th Amendment was the Civil Rights Act of 1957, which created the United States Commission on Civil Rights. One of the Commission's major duties is to inquire into claims of voter discrimination. The Commission reports its findings to Congress and the President, and through the media to the public. The 1957 law also gave the Attorney General the power to seek federal court orders to prevent interference with any person's right to vote in any federal election. The Civil Rights Act of 1960 added on additional safeguard. It provided for the appointment of federal voting referees. Those officers were to serve anywhere a federal court found voter discrimination. They were given the power to help qualified persons to register and vote in federal elections. The Civil Rights Act of 1964. The Civil Rights Act of 1964 is much broader and more effective than either of the two earlier measures. It outlaws discrimination in several areas, especially in job-related matters. With regard to voting rights, its most important section forbids the use of any voter registration or literacy requirement in an unfair, discriminatory manner. In the 1964 law continued a pattern set in the earlier laws. It relied on judicial action to overcome racial barriers and emphasized the use of federal court orders called injunctions. An injunction is a court order that either compels or restrains the performance of some act by a private individual or by a public official. The violation of an injunction amounts to contempt of court, a crime punishable by fine and or imprisonment. Dramatic events in Selma, Alabama soon revealed the shortcomings of this approach. Dr. King mounted a voter registration drive in the city in early 1965. He and his supporters hoped that they could focus national attention on the issue of African American voting rights, and they most certainly did. The registration efforts were met with insults and violence by local white civilians, by city and county police, and then by state troopers. 3 civil rights workers were murdered and many were beaten when they attempted a peaceful march to the state capitol. The nation saw much of the drama on television and was shocked. An outraged President Lyndon Johnson urged Congress to pass new and stronger legislation to ensure the voting rights of African Americans. Congress responded, and quickly. Voting Rights Act of 1965. The Voting Rights Act of 1965 made the Fifth Amendment at long last a truly effective part of the Constitution. Unlike its predecessors, this act applied to all elections held anywhere in this country, state and local, as well as federal. Originally, the Voting Rights Act was to be in effect for a period of 5 years. Congress has extended its life on 4 occasions in the Voting Rights Act amendments of 1970, 1972, 1982, and most recently, 2006. The present version of the law was made effective for 25 years. Its revisions will not expire until 2031. The 1965 law directed the Attorney General to challenge the constitutionality of the remaining state poll tax laws in the federal courts. The provision led direct to Harper and Virginia Board of Elections 1966, as you may recall from Section 2. The law also suspended the use of any literacy test or similar device in any state or county where less than half of the electorate had been registered or had voted in the 1964 presidential election. The law authorized the Attorney General to appoint voting examiners to serve in any of those states or countries. It also gave these federal officers the power to register voters and otherwise oversee the conduct of elections in those areas. Preclearance. The Voting Rights Act of 1965 created a further restriction on those states where a majority of the electorate had not voted in 1964. The act declared that no new election laws and no changes in existing election laws would go into effect in any of those states unless first approved, given pre-clearance by the Department of Justice. Only those new or revised laws that did not dilute the voting rights of minority groups can survive the pre-clearance process and take effect. The pre-clearance hurdle had produced a large number of court cases over the years. Those cases show that the law most likely to run afoul of the pre-clearance requirement are those that make these kinds of changes. 1. The location of polling places. 2. The boundaries of election districts. 3. The deadlines in the election process. 4. A shift from the ward or district election to at-large elections. Or 5. The qualifications candidates must meet in order to run for office. Any state or country subject to the voter examiner and the pre-clearance provisions can be removed from the law's coverage through the bailout process. That relief can come if the state shows that the United States Court District and the District of Columbia that it has not applied any voting procedures in a discriminatory way for at least 10 years. The Voter Examiner and Pre-Clearance provisions of 1965 Voting Rights Act originally applied to 6 entire states: Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. They also applied to 40 countries in North Carolina. The Supreme Court upheld the Voting Rights Act in 1966 in South Carolina versus Katzenbach. A unanimous court found the law to be a proper exercise of the power granted to Congress in Section 2 of the Fifth Amendment. That provision authorizes Congress to use appropriate measures to enforce the constitutional prohibition prohibition against racial discrimination in voting set out in Section 1 of the amendment. Amendments to the Act. The Voting Rights Act Amendment of 1970 extended the law for another 5 years. The 1968 elections were taken into account in determining jurisdictions with concerns, and the results was that a number of countries in 6 more states, Alaska, Arizona, California, Idaho, New Mexico, and Oregon, were included in the law's coverage. That 1970 law also provided that for 5 years, no state could use literacy as the basis for any voting requirement. That temporary ban, as well as residence provisions outlined in the law, were upheld by the Supreme Court in Oregon v. Mitchell in 1970. In 1975, the law was extended again, this time for 7 years, and the 5-year ban on literacy tests was made permanent. Since 1975, no state has been able to apply any sort of literacy qualification to any aspect of the election process. The law's voter examiner and pre-clearance provisions were also broadened in 1975. Since then, they have also covered any state or country where more than 5% of the voting age population belongs to certain language minorities. These groups are defined to include all persons of Spanish heritage, Native Americans, Asian Americans, and Alaskan Natives. This addition expanded the law's coverage to all of Alaska and Texas, and to several countries in 24 other states as well. In these areas, all ballots and other official election materials must be printed both in English and in the language of the minorities involved. In 1982, amendments extended the basic features of the Act for another 25 years. In 1992, the law's language minority provisions were revised. They now apply to any community that has a minority language population of 10,000 or more. Over the years, several states and a handful of counties in a few other states have been removed from the law's coverage through the bailout process. Today, 8 entire states remain subject to the Voting Rights Act: Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, and Texas. At least some counties in 6 other states are also covered by the statute: California, Florida, New York, North Carolina, South Dakota, and Virginia, as well as 2 townships in Michigan and 10 towns in New Hampshire. The end.